Good afternoon, good day, everyone. I welcome all of us to this final Moot Court competition. Today is the finals for the Moot Court competition for law students in Nigeria. And the host for this program is Honorable Justice Innocent Umezulike Foundation here in Nigeria. This is the first live virtual Moot Court competition ever to hold in Nigeria. And so I welcome all of us again, especially the judges, His Lordship Olumide Agbede. We also welcome His Lordship Ifi Ejeta to the platform. We welcome all the councils. Yes, welcome all of you, Team Ruby, and what's the other team? Team Diamond. Yes, I welcome Team Diamond. I welcome Team Ruby to the finals. And then I also welcome our bailiff, Chibuzo Obiora. Thank you so much for being part of this program. I welcome all our admins, staff, and members of Honorable Justice Innocent Umezulike Foundation. So quickly, I would delve into the introductions about our organization, and then we will introduce today's program formally. Okay, so about our foundation, Honorable Justice Innocent Umezulike Foundation is an international non-governmental organization formed to honor the legacy of late Honorable Justice Innocent Azubike Umezulike, who at the time of his death was an acclaimed professor of land and property law, authored over 25 books, and served as Chief Judge of Enugu State, clinching the longest serving Chief Judge in southern Nigeria. The foundation delivers its mission through the promotion of excellent legal education, research, and charity initiatives. Some of our facilities and programs include Law Library, Legal Research Center, annual lectures, workshops, and seminars, educational grants, and then funding. And then our projects, what do we do, or what are we known for? I mentioned Law Library earlier. As an organization that is focused on building the capacity of law scholars and lawyers through legal education or research, the Honorable Innocent Umezulike Law Library provides members with access to millions of printed law texts and visuals covering different aspects of law. This is to ensure that all legal scholars and lawyers through our facilities and programs are well equipped to get the necessary skills and knowledge that would support their development. For example, interns, volunteers, and partners enjoy free membership and have access to all materials in the library. And then recently, of course, we conducted an internship program for law students in Nigeria. Over 200 law students in Nigeria registered for that program. And so they are the interns of our foundation. And then we also have the annual lecture. This is an important part of our project because it serves as a memorial for His Lordship. Every year, an annual memorial lecture is held in honor of His Lordship, and it features a convergence of intellectuals in academia, bar, bench, and politics to discuss contemporary legal issues and challenges in the Nigerian legal system. The first annual lecture and book presentation held on 27th September 2019 at Honorable Justice I.A. Umezulike Auditorium, High Court of Justice, Enugu State, Nigeria. It featured the launch of the book, Honorable Justice Innocent Umezulike, A Chronicle of Leading Judgments, Volume 1. The foreword of the book was written by the Chief Justice of Nigeria, Honorable Justice Tanko Mohammed, CFR, as then was. And this year, the annual lecture we hold in London, United Kingdom. Part of our project and what his lordship holds so dear to his heart is legal education, law text. He wrote, I mentioned earlier that he wrote over 25 law books, and amongst them are just a few of them displayed, at least for the purpose of the program we are doing, and then specifically for law students in Nigeria. We have here the Chronicles of Leading Judgments, Volume 1, and then we have the ABC of Contemporary Land Law in Nigeria, and then finally the New Weeks and the Challenges of Legal Practice in Nigeria. If you go through this text, you would see that they are so relevant to our present day legal education and law practice. And then we have the grants and scholarship. The Honorable Justice Innocent Umezulike Foundation provides grants to law scholars to help support their dreams of becoming lawyers and contributing to the development of a more civil society. This is also a core part of our program in our foundation. We support highly qualified and intelligent law students to achieve their dreams of becoming lawyers. This is one of our non-legal education projects, the charity project, that is the Innocent Project. The Innocent Project is a grassroots initiative aimed at empowering small and medium-sized charities, NGOs, and businesses to join forces and resources for a global impact. Of course, we carry out several interventions as the need arises to help the downtrodden and to help those who are in their need. Where can you find us? Of course, we're on social media. Our website is www.umezulikefoundation.org. Our email is admin@umezulikefoundation.org. If you have any question, you have things you would like to know about our organization, you can mail that address. And then on Twitter, we are at IAU_foundation, Instagram at Umezulike Foundation, and then on Facebook, Honorable Justice Innocent Umezulike Foundation. So that is it about our organization. Today, I welcome all of us again back to the live virtual Moot Court competition for law students in Nigeria. Last week, we had a very robust session with 4 teams. I will quickly display the qualifying groups. Last week, we had 2 groups, Group A and then Group B. In Group A, we had the team Diamond, represented by Chinedu Patrick Aneke and Victoria Udo from the University of Nigeria. They were the plaintiffs in the matter. And then we have Team Sapphire, represented by Inyang Esther Elijah and Gabriel Eversam Lista from the University of Uyo, Nigeria. They were the defendants in the matter. And then in the Group B, we had University of Benin, Team Ruby, represented by Braham Paul C. Piper Chima and Philip Kefas Terry. They were the plaintiffs in the matter. And then we had Team Emerald, represented by Ismail Khadijat Moromoke and Ibrahim Karibat Adedoyi from University of Nigeria. They were the defendants. And then this is the score sheet. If we look carefully on the screen, we will see the score sheet for the last competition. We had made the announcement earlier in the week to the participants, but here on this live program, we are displaying on the screen how the competition went. For Group A, now, if you look at the top part of the bar, you will see the various criteria for marking or for judging the competition. We have 20% advocacy, written address 20%, the courtroom language 10%, composure 10%, dressing 10%, time management 10%, submission and prayers 20%, and that brings it to a total of 100%. And then in Group A, Team Diamond went against Team Sapphire. The Team Diamond got a total of 90, and then Team Sapphire got a total of 62. And so that made Team Diamond the winner of Group A. And then in Group B, we had Team Ruby as the plaintiff and Team Emerald as defendants. Team Ruby came out with a total of 82 points, and then Team Emerald came out with a total of 63 points, making Team Ruby the winner of the Group B. And so today we have the finalists for today's competition. Team Diamond, the plaintiff, the counsel, VI, Udo, and Chinedu Patrick Aneke. And then, of course, Team Ruby, the defendants, counsel P. Chima and Katie Philip. So I welcome all of us again to this competition, and I hope that we'll have a very memorable session, both with the judges and with the counsels ably represented. So if we are ready, the bailiff, please call a case.
Good afternoon, everyone.
Good afternoon.
Good afternoon. Welcome again, once again, to the Justice Umezulike Moot Court finals. Today, the matter before us today is between Mrs. Ibinabo, the plaintiff, and the defendant, Mr. Akin. And I would like to call on the counsel for the plaintiff, Mrs. Ibinabo, Team Diamond, to commence their arguments.
Thank you.
Counsel for the plaintiff, you can commence. You can commence. Counsel for the plaintiff, Ibinabo, you can commence.
Forgive me, Your Lordship, my co-counsel is having a bit of network issues. He's trying to connect.
Okay, I think he's online. He's online. Is it a problem with the audio now, or?
Can you check and unmute or something?
We can't hear you, counsel. That's why, but you tested the audio earlier. We heard you correctly the first time. So what seems to be the problem? Please check the earpiece.
The plaintiff, Binabo Ololade. Luckily, the matter today is for adoption of briefs and adumberation of arguments by parties when necessary. Before this court, Your Lordship, is a plaintiff's written address dated the 8th day of July 2022 and filed on the same day. Your Lordship, the plaintiff moves to adopt this written address, the arguments therein, and the prayers as its arguments before this court. With the kind leave of the court. Thank you very much, Your Lordship. Thank you, Your Lordship. Before we proceed to our arguments, they would have to like to give a brief summary of the facts upon which this case is built. Your Lordship, the summary of the fact basically is that the plaintiff is the granddaughter of a certain Mr. Smith Ololade, who is the father of the defendant. After the death of Mr. Smith Ololade, who had 3 children, the plaintiff's mother, the defendant, and the 3rd son, the family agreed to elect the defendant as the family head. Immediately upon inception of authority as the family head, the defendant sold the family's rubber plantation without consulting any member of the family and used the proceeds of the sale to pay his children's school fees. Subsequently, the plaintiff's mother, Miss Edith, before her death, gave birth to the plaintiff out of wedlock. She remained unmarried and maintained her status as an Ololade and maintaining her daughter's status as a member of the Ololade family. Upon her death, Your Lordship, the Ololade family agreed to sell their cocoa, a portion of their cocoa plantation, in order to use the proceeds of the sale to finance her burial. The sale was conducted by the family head, Mr. Akin, the defendant in this case, on behalf of the family. At the end of the sale, he received the payment of 2 million naira on behalf of the family, but remitted only 200,000 naira to the family and kept for his own private use and advantage a whooping sum of 1.8 million naira from the family. Fellowship, on the basis of this, the plaintiff, dissatisfied as a family member, has brought this action to protect her interest in the proceeds of the family property. From these facts, Your Lordship, the plaintiff has distilled 3 issues for determination. 1, whether the plaintiff has locus standi to bring this action. 2, whether a family head can sell family property as his personal property, or alternatively, without the consent of principal members of the family.
Or alternatively, on the alternative, other members,
Yeah.
I didn't get that.
Without,
Sorry.
okay, or alternatively, Your Lordship, without the consent, of principal members of the family.
Okay, thank you.
Okay, thank you. 3, Your Lordships, whether the court can make an order directing the defendant, whether the court can make an order directing the defendant to give account of his administration of family property.
To give account of what?
Of his administration of family property.
Okay.
My co-counsel, VI Udo, will canvass the merits of the first issue, and I'll canvass the merits of the second and third issue. With the kind leave of this court, I'd like to invite my co-counsel to proceed with the arguments on the first issue.
Proceed.
Thank you.
May it please this honorable court, Your Lordship, can I be heard?
Very clear.
Thank you very much, Your Lordship. Respectfully, VI Udo, counsel for the plaintiff in the matter before you, Your Lordship. And for the sake of this case before you, Your Lordship, I would be canvassing the merits of issue 1, whether the plaintiff, Mr. Binabo, has local standards to bring this action before this honorable court. On this issue, it is counsel's humble submission that the plaintiff has the local standing and the right under law to bring this action before this court. The basis of this submission is that the plaintiff is a legitimate and bona fide member of the Oloalade family, and by virtue of this, has the right to institute proceedings requesting for the account of the management of the family property by the family head, Mr. Akin, the defender. Your Lordship, it is straight in law that the issue of local standing is very germane and paramount to any legal proceeding. The court in the celebrated Supreme Court case of Daniel and INEC, Independent National Electoral Commission, Your Lordship, a 2015 case decided by the Supreme Court. The justice, Rhodes Visor, had categorically defined local standing to be legal capacity to institute proceedings. Also, in the case of Ajayi and Adebiyi, a 2012 case decided by the Supreme Court, The court had categorically stated that on no account should the merit of a case be canvassed when the court has not decided if parties have local standing to bring the matter before the court. Your Lordship. Furthermore, on the locus classicus case of Adesanya and the President of the Federal Republic of Nigeria, a 1981 Supreme Court case, the court had listed out the attributes of local standing, stating that for a person to be categorized as having the right to institute a matter before a court, his or her personal interest must have been affected, or his or her personal interest is on the verge of being affected by the actions of another party, or there are dangers of him sustaining injury to himself. The Court of Appeal, in a 2007 case of Ama and Wankwo, Your Lordship, laid out 3 tests for local standing. That 1, the action before the Honorable Court must be justiciable. 2, there must be an existence of a dispute or threat to the interest of the plaintiff, such that such interest is affected by the actions of another party. This was also the position of the court in UBA PLC, and BTL International Limited, a 2004 case decided by the Supreme Court. Hence, for a court to hold that a party has local standing to a matter, his rights or his interest in a particular matter must have been threatened by another party, or there was an existence of dispute between any party. Furthermore, Your Lordship, having made submissions as to the judicial authorities on local classification, it is straight in law that any member of a family has the capacity to institute a proceeding or to sue to protect his interest, his or her personal interest in family property. This was the decision of the case in a very recent case, a 2022 Court of Appeal case, Mr. Godsnow Amadi, Mr. Godsnow Amadi, Your Lordship.
Godsnow?
Godsnow, yes, Your Lordship.
Okay,
Godskan, yes. Thank you, Your Lordship. In this case, the court had emphasized that where the interest of a family member is being affected, such family member has the right to institute an action before the court to protect that interest. In this particular Godsnow case, the court emphasized a superior case that was held in 1972, a Supreme Court case of Ami Mashon and Osuma. All citations are in our written address, Your Lordship. Ami Mashon and Osuma. Hence, it is the position of the court that any member of the family who feels that their interest is being affected by any other member of the family or the family head in question has the right to institute an action before this court. Your Lordship, the question becomes, who is a family member? Who is this member who can institute an action before a court of competent jurisdiction? This question was answered in the celebrated Supreme Court of Okulate and Awonsanya. Okulate, spelled as pronounced, Your Lordship. Okulate and Awonsanya, a 2000 Supreme Court case, where the justice defined a family to be a body of persons, including parents and children, whether living together or not living together, and in large, people who are bound by blood or affinity, or people who have common ancestors or kindred. So where there are a group of people that have common ancestors, they are deemed family, and any member from that group is deemed a family member. This was also the position of the court in MTN Nigerian Communication Limited and Emegano case held in 2016. MTN Communications Limited and Emegano. Your Lordship, having identified who a member of the family is, the question becomes, are there instances where a person could be sidelined from being a family member or disallowed from having interest in family property by circumstances of their birth? And the answer, submission before of counsel before this honorable court, is no. In the most celebrated case of Ukeje and Ukeje, UKEJE, Your Lordship, Ukeje and Ukeje, a 2014 case decided in the Court of Appeal, the court stated, and I quote, "No matter the circumstances of the birth of a female child, such a child is a legitimate member of the family and is entitled to the family estate. Hence, the circumstances of the birth of a particular child, female or male, does not affect his rights in the estate of a particular family. This was also the decision of the court in Amusan and Olawuni, a 2001 case decided by the Court of Appeal. Going forward, Your Lordship, a submission of counsel that the late Miss Esther, the mother of the plaintiff, Miss Ibinabo, was a bona fide member of the Olade family and had the plaintiff, Miss Ibinabo, out of wedlock. However, this did not change the status of Miss Ibinabo, the plaintiff, as a bona fide member of the Olade family. For the court to hold that Miss Ibinabo is not a member of the family would be a clear contravention of Section 42 of the 1999 Constitution, that they clearly point out that no person shall be discriminated or deprived of certain rights by virtue of the circumstances of his birth. And it would be a miscarriage of justice for this honorable court to find that Miss Ibinabo is not a member of the Olade family by the fact that she was born out of wedlock. Your Lordship, the facts are clearly undisputed. There was no legitimate marriage between the late Miss Esther and the Ijaw prince. Hence, after giving birth to Miss Ibinabo, the plaintiff, she retained her status as a member of the Ololade family. There was no change in title. There was no transfer in title. Hence, her descendants and her only daughter, Miss Ibinabo, remains a bona fide member of the Olade family. Having established that the plaintiff is a bona fide member of the family, Your Lordship, the law provides in the same UKJ and OKJ, and in this celebrated case, Supreme Court case of Akinubi and Akinubi, Your Lordship, in 1997 case, that where a family member died, his estate devolves to his successors or his children, who can sue to protect their interest in the family property. Your Lordship, Miss Esther was a bona fide member. Late Miss Esther, the mother of the plaintiff, was a bona fide member of the Olade family. And following the principle in OKJ and OKJ, as well as Akinubi, upon her death, her estate devolved to Miss Ibinabo, the plaintiff in this matter, giving her every right and local standing to bring a matter before the court, asking that the family head account for his management and use of the family property. Hence, the undisputed fact remains that Miss Esther, the only daughter to Mr. Smith Olade, the family head, gave birth to Miss Ibinabo. Having devolved her estate upon her death, Miss Ibinabo has every right to institute an action against the plaintiff, against the defendant in this matter. It's upon these principles, as well as the judicial cases submitted by counsel, that we pray this honorable court, that counsel prays before this honorable court, that this honorable court finds that the plaintiff has local standing as a bona fide family member of the Ololade family to institute this action. May it please this honorable court. Your Lordship, I will hand over to my lead counsel to canvass the merits of issue 2 and issue 3. May it please this honorable court. Thank you, Your Lordship.
You're welcome.
As it pleases this court, Your Lordship, I would be canvassing the merits of the third and the fourth issues, the second and the third issues, rather. On the second issue, Your Lordship, whether a family head can sell family property, his own personal property, or alternatively, without the consent of the principal members of the family. Your Lordship, it is our humble submission that a family head cannot transact on family land as his own personal property, or alternatively, without consulting and obtaining the consent of the principal members of the family. Our submission on this issue, Your Lordship, is two-armed. On the first arm, it is our submission that the conduct of the defendant by selling the family's rubber plantation without consulting any member of the family and using the proceeds of this sale, Your Lordship, to pay his children's school fees is a conduct which amounts to the fact that he transacted in the family land as his own personal property and to his own advantage. And it is the law that where a family head does this, such transaction is void ab initio. Your Lordship, this was the position of the Supreme Court in the 2013 case of Achihili and Anyatong, Achihili and Anyatong, where the court emphasized that in the event that a family head sells or wants to sell family property as his own personal property, such transaction is void ab initio because the principle nemo dat quod habet will apply, and by implication, you cannot give what you don't have. This, Your Lordship, was reiterated by the Supreme Court in the case of Ejile Mele and Opara 2003. Your Lordship, on this standpoint and on the basis of this principle, we submit that the action of the defendant by selling the family's rubber plantation as his own is void ab initio. On the second standpoint, Your Lordship, it is our submission that if this court holds in the alternative that the defendant transacted in the sale of the family's rubber plantation as the family head and on behalf of the family, we still submit that such transaction becomes voidable, Your Lordship, at the instance of the family members because the family head did not consult or obtain the consent of the principal members of the family. Your Lordship, in considering this issue, the holding of the Supreme Court by Nikitobi JSC in the case of Usio Baifo and Usio Baifo, USIOBAIFO, a 2005 case, Your Lordship, is very germane, and I seek the leave of this court to read.
Proceed.
In that case, thank you, Your Lordship. In that case, Your Lordship, the court held that where the family head sells family property without the consent of the principal members of the family, the sale is voidable. Unimpeachable title can only be transferred from one family to another, where the family head transacts with the concurrence and consent of the principal members of the family. This was reiterated by the Supreme Court, Your Lordship, in the case of Ofodile and Ofodile, 2019. Going forward, Your Lordship, the Court of Appeal in the 2022 case of Bello and Idris succinctly held that where a sale of family property has been held to be voidable, the court has the power to void such transaction or set it aside upon application by any member of the family. According, Your Lordship, the plaintiff, a bona fide member of the Olulade family, has brought this action to avoid or apply to the court to set aside this transaction by the defendant without the consent of principal members of the family. And on the basis of this principle, we pray this honorable court to hold on this second issue in favor of the plaintiff. On the third issue, Your Lordship, whether this court can make an order directing the defendant to give account of his administration of family property. It is our humble submission, Your Lordship, that the court has the power to make such orders. Your Lordship, the crux of our submission is that the defendant, as the head of the Olulade family, holds the family property as a trustee, and as such, he has a fiduciary duty to act in relation to this property in the best interest, Your Lordship, and benefit of the family, and not to his personal advantage or interest. Your Lordship, these were the words of the Supreme Court in the 2014 case of Anyafulu Admeka. Progressively, Your Lordship, in Ebosie and Field Ebosie, EBOSIE, and Field Ebosie, the Supreme Court of JSC emphasized that a family head as a trustee must not convert the revenue or proceeds from the sale of family property to his personal advantage. And where a family head does so, Your Lordship, the Court of Appeal in the 2016 case of Eso and Sule. Eso and Sule held that the courts have exercised and will continue to exercise their right to make such order as will ensure that all the members of the family enjoy their full rights and interests in the family property. The Lordship, is on the basis of this principle that the Supreme Court, in the case of Taiwo and Dosun, held that a family head shall be directed to give account of his administration of family property, depending on the circumstances of each case. In Akande and Akambi, the Supreme Court held, and I seek the leave of this court to read the exact quotations of the court. The court, Your Lordship, held that the failure to impose a duty to give account on the family head will lead to fraud and negligence. Accordingly, where a family member can point to a definite act of delinquency amounting in effect to a breach of trust by the family head, such an act as the fact that the family head is an avaricious man, a greedy man, Your Lordship, seeking always to take more than his fair share of the family property or proceeds, the court will order an account to be given by the family head. In this case, Your Lordship, the plaintiff points to two definite acts of delinquency on the part of the defendant. One, that he sold the family's rubber plantation without consulting anybody and used all of the proceeds of the sale for his own personal advantage by paying his children's school fees. Two, that he received payment of 2 million naira as payment for the sale of the family's cocoa plantation and remitted only 200,000 naira to the family, keeping a whopping sum of 1.8 million for his own personal advantage in his savings account. The Lordship, all he remitted to the family was 10% of the amount and held on to 90%. The Lordship, receives some loquitur. These facts, Your Lordship, speak for themselves to the avariciousness and greediness and delinquencies of the defendant as the head of the Olulade family and the misuse of the family proceeds. And accordingly, warrants circumstances for the court to make an order directing him to give an account of his use of the family properties since his inception as the head of the family. On the basis of this, Your Lordship, we pray this court to resolve this issue in favor of the plaintiff. Your Lordship, on the basis of this argument, the and prayers contained in its written address filed before this court as its prayers before this court. May it please this honorable court.
Belif, can you kindly tell us how many minutes they spent? How many minutes left for rebuttals? Belif, please.
Okay, they have a total of 9 minutes remaining.
Okay, 9 minutes for your rebuttals. Take notes. So,
Yes.
Belif, kindly
Yes.
call if our judges have questions, they can do that, or we'll call the next. We'll call the defendants.
Okay. Any questions?
I might. I would like to make my comments if we have my end of the submission generally. I hope I can reserve my comments till that time.
As a court pleases.
Thank you.
Okay, Bill, if you can call the next one.
Okay. May I call the counsel for the defendant, Tim Ruby, to commence the argument?
Your Lordship, first appearance is the defendant. Your Lordship, I'm here alongside my co-counsel, Katie Philip. Katie Philip. Your Lordship.
Counsel, sorry, can you take it all over again? We didn't get your name.
My name is Chima. P. Chima.
I think my learned brother is saying something.
Okay.
My brother, I think you need.
I cannot hear you, Your Lordship. I can't hear you.
Hello.
No, I can't.
Counsel, I don't know if you have any speaker or any thing that is making sound around you. It's blocking
I do not.
your voices.
It's quite weak. However,
We can barely hear you, Counsel. We can barely hear you, Counsel.
If it's windy, can't you look for a place that is
Do you have
enclosed
an earpiece?
can you hear me now?
Oh yeah. If
can
you
hear
have
me
an
now.
earpiece, it will be better. Okay.
Sit now with your kind leave. Thank you, Your Lordship. Your Lordship, commencing appearance is P. Chima. Chima is spelled C-H-I-M-E. Your Lordship, I appear on behalf of the defendant, who is Akin, who has been sued before this court. And I appear alongside my co-counsel, S. Ugu. S. Ugu. Your Lordship, I would like to bring it to the notes of this court now that when the information for the finals was stated, I brought to the notice of the court that my co-counsel, Katie Philip, will not be able to make this proceeding, being that he has another proceeding going on right now, that's the Nuremberg International Moot Court. And I sought the leave of the court for another person to stand in his place, and it was granted by this same court. I wish to bring it to the notice of the court. That is why S. Ugu is standing in for Katie Philip. Thank you, Your Lordship. Your Lordship, before this honorable court is a memorandum of appearance that have been dated and filed on the 8th of July, 2022. Also, we filed a written address alongside the memorandum of appearance, and we distilled 3 issues for determination. In the said written address, the first issue is whether the plaintiff has the local standard to institute this action against the defendant, who is the family head of the Olu Lades family. Your Lordship, may I proceed?
You have to take it and go slowly, please.
Okay.
That's why writing longhand. Thank you.
Okay. As properly guided, Your Lordship.
Whether the plaintiff
has the local standard to institute this action against the defendant, who is the family head of the Olu Lades family. However, Your Lordship, I would like to also bring to note of because that these issues have already been distilled, is contained in our written address. So we do not know if the court will allow us to just proceed, being that it's already in the written address.
Have you filed this written address?
Yes, the written address was filed by 12 o'clock as this court mandated us to file the said written address.
I believe it's in your best interest that you
Okay. As properly guided, Your Lordship. The second issue is whether the defendant can be mandated to render an account of the money derived from family assets.
Of the money
derived from family assets, whether the defendant can be made to render an account of the money derived from family assets, Your Lordship. And the last and final issue is whether the plaintiff has an interest in her maternal grandmother's estate, maternal grandfather's estate, rather. Your Lordship, I'll repeat, whether the plaintiff has an interest in her maternal grandfather's estate. Your Lordship, this is the last and final issue of the defendant with distinct three issues. With your kind permission, I'd like to proceed with the issue on local standard, which is the first issue. Thank you, Your Lordship. Yes. Your Lordship, yes. Your Lordship, the issue of local standard has to do with the standing to bring a suit. In the case of Bakari versus Ajose Adeogo, the 2014 is contained in our written address, the Supreme Court case. The Supreme Court stated that local standard refers to the standing of a person to bring an action. That is, it is only a person who has an interest or a stake in a certain matter that can bring a suit in respect of such matter. Your Lordship, this is the position of the law. Premised on this, the defendant shall be making submissions on three standpoints. The first standpoint is that the plaintiff is not a member of the Olo Lades family. The second standpoint is that Ibinabo is a meddlesome interloper. And the third standpoint is that there is no express authorization or consent by any other family member for the plaintiff to institute this action before this court. Your Lordship, I shall now begin with the first standpoint. The first standpoint concerns whether Ibinabo is a member of the Olu Lades family. Your Lordship, the position of the law for a person to be a member of a said family, particularly a monogamous family, as in this instant case, was established in the local classical case of Coker and Coker, 1938. Coker and Coker, 1938, as contained in our written address. In this said judgment, the court stated that it is only the direct offspring of the founder of a family that are said to be members of that particular family for the purpose of land interest. Your Lordship, this particular position was also upheld and reaffirmed in the case of Adesheye and Taiwo. Adesheye and Taiwo, 1956, Federal Supreme Court. The court affirmed that if a family member is a person who is the direct offshoot of the founder of that said family, particularly in a monogamous family. Your Lordship, looking at this case fact, it is obvious that the type of family in dispute here has a monogamous nature. And Ibinabo is the daughter of a child of Mr. Smith, the founder of this family. However, Ibinabo was begat to an Ijaw prince, and Ijaw prince as stated in lines 9 of the case fact. It is premised on this that the defendant is submitting that Ibinabo is an Ijaw by tribe, being that she was given birth to by a child of Mr. Smith to an Ijaw prince. And this makes her not to be a family member in line with the decision of Coker and Coker and Adesheye and Taiwo, making her to be a direct offshoot of Mr. Smith. We are submitting on this standpoint that Ibinabo is not a member of the Ololades family. Your Lordship, on the second standpoint, which is that Ibinabo is a meddlesome interloper, Your Lordship, we rely on the case of Taiwo versus Adegboro, 2011 Supreme Court, and also the case of Ibe versus Okonkwo, 2020 Court of Appeal. This is contained in our written address. In this said case, the court stated that a meddlesome interloper is a person that does not have an interest or a stake in a particular subject matter. Your Lordship, looking at the case part, Ibinabo, who is the daughter of an Ijaw prince, does not have a stake in a matter that it does not involve her own family. Your Lordship, this is like me, a counsel, having to tell another man's, having to tell Buhari or someone else how he should render or observe practices in his own family. In this particular circumstance, Ibinabo, being a daughter of an cannot interfere in the family matters of Mr. Smith, which is the Ololade's family. And we are submitting on this point that Ibinabo is a meddlesome interloper. Lordship, on the last standpoint, which is that there is no express authorization or consent that has been given by any other family for Ibinabo to take this action. Lordship, Imiran Oluwole Smith, in his practical approach to the law of real property, published in 2013, stated that for a person to be able to bring a suit, in customary law, such person cannot just bring the suit by him or herself. He must seek the consent of other family members. This particular position was affirmed in the case of Ajo Magberin versus Salau, 2018. This is a Court of Appeal judgment, 2018. The court stated that in customary law, for a person to bring an action against the family head, such person must seek the consent of other family members. Without seeking the consent of other family members, you cannot bring an action against the family head. So a person cannot bring an action suo motu without the authorization of other family members. Your Lordship, looking at the case fact, there's nowhere it is stated that Ibinabo sought the consent of other family members. Persons like Dauda, who in lines 1 is also a member of this said Ololade's family. She never sought his consent. She just came suo motu to this court. Your Lordship, it's premised on this that we are submitting, pursuant to the case of Ajo Magberin and Salau, that the plaintiff never sought an authorization from other family members to bring this said suit. Therefore, we are submitting finally that 1, Ibinabo is not a member of the Ololade's family. Secondly, Ibinabo is a some interloper. And lastly, if at all she should be held to be a member of the Ololade's family, she has not sought the requisite consent necessary for her to bring an action against the family head. And we are submitting that this court holds this issue and grants it in favor of the defendant. Your Lordship, why the plaintiff was making his submission, the plaintiff referred to the issue of legitimacy. We want to point out that the issue of legitimacy does not apply in this particular scenario, in the sense that it is not the estate of the Ijaw prince that is in contention here. Legitimacy only comes into play when a person is about to be denied of what he ought to be entitled to as a child. In this particular circumstance, we are talking of a person who is looking for an account, who is seeking for the family head to render an account. She's not about to be deprived of any family estate. Hence, we are submitting that argument made by the plaintiff counsel as to legitimacy does not apply here. This concludes the argument for issue 1. The Lordship, I shall now proceed to my second argument, which has to do with whether the defendant, who is the family head, can be made or mandated to render an account of the money derived from family assets. And with the kind permission of this court, I would like to proceed.
Counsel, this is the belief. You have 2 minutes more.
2 minutes from 30 minutes, I would like to be cleared, please.
From 2 minutes from 15 minutes.
Okay, thank you. Your Lordship, it is the position of the law that a family head is in the position to manage the family estate, the family land, and the family properties. And if he sells these properties, he is to use it for the general welfare of the said family. Your Lordship, premised on this, counsel will be making submissions on 3 standpoints. The first standpoint is that a family head is in the shoe of the founder of the said family. The second standpoint is that a single family member cannot bring an action suo motu without the support of other family members. And lastly, the last standpoint is that where there's a misappropriation, the proper remedy is for the said family heads to be removed and not to be mandated to give an account. The Lordship, on the first standpoint, we are submitting, pursuant to the case of Odiachi versus Odiachi, 1980 Supreme Court, contained in our written address, and also the case of Ebose and P. Ebose, 1976 Supreme Court also. the court stated that a family head is in the position of the founder of the family. And just the way the founder of the family can utilize money, the way he wants to utilize money, without anyone questioning him, so can the family head do. In this particular circumstance, line 3 of the case part tells us that Akin, the defendant, was elected as the family head of the Ololades family. Pursuant to that, we are submitting that this puts him in the position of this puts him in the shoe of the founder of the said family, and hence he can utilize the money derived from the family assets for the welfare of the family and without any recourse to give an account. Moving on to the second standpoint. The second standpoint is that a single member cannot demand for an account of family money, the account of family money derived from family assets. We premised our submission on the case of Kosoko and Kosoko, where it was stated that a single family member, without the authorization of other family members, cannot seek from the family head an account on how family money was utilized. And on the third standpoint, which is where there's a misappropriation, the proper thing to do is to demand that the family head be removed, and not for money, and not for him to account for the money derived from family assets. Your Lordship, we are premising our submission on the case of Lopez and Lopez, 1924. Also, the case of Nelson and Nelson, 1951. And also the case of Agara and Agumbiadi, 2012, contained in our written address. It was the position of the court that where a family head is taken to have misappropriated money, the proper remedy is to remove the family head from the said position of the family head, and then he can give an account. Not when he's a family head, he should render an account. Your Lordship, we are premising and submitting before this court that the defendant cannot be mandated to render an account, being that he's still in the position of the family head. And the rationale for this particular position, particularly as stated in the case of Agara and Agumbiadi, is that a family head setting him to render an account for the money utilized places him in a position of ridicule, and this is not the position in regards to customary law. Your Lordship, we are therefore submitting that the defendant cannot be made to render an account on the money derived from the use of family assets, and we pray that this court resolve this issue in favor of the defendant. Your Lordship, further, I wish to bring this to the notice of the court. Why the plaintiff was making submissions on his argument. The plaintiff referred to Mr. Akin as a trustee. Your Lordship, we wish to state that there's a difference between a trustee in English law and customary law, the position of a family head. For there to be a trust relationship, there has to be a set law. In this particular instance, the question might arise, who is a set law? Your Lordship, that particular question cannot be answered from the case part. Hence, the argument on a trustee relationship cannot be applied in this particular scenario. And we are submitting that this court should not rely on the said argument made by the plaintiff counsel. Your Lordship, this concludes the defendant's argument on issue 1, which has to do with local standard, and issue 2, which has to do with the rendering of accounts. Thank you, Your Lordship. At this particular point, I'd like to defer proceeding to my learned co-counsel, S. Ugu, on the last issue before the scope.
Yes, sir.
Okay. Your Lordship, can you hear me?
Quite clearly.
Yeah.
Okay. Good day, Your Lordship. May it please the court. Entering appearance is S.O. Ubu. Your Lordship, for the sake of clarity, Ubu is spelled as U-G-W-U. I am a co-counsel for the defendant in this case, and I shall be arguing on issue 3, which is to the effect whether the plaintiff, Ibinabo, is entitled to a share in her maternal grandfather's estate. And my lordship, I am not here on my own wisdom. Rather, I am here with arsenals of judicial authorities to back up my argument. And my argument shall be premised on two standpoints, which are, the first standpoint is that the plaintiff's mother, Esther, is a joint tenant with no separate share in the property of late Mr. Smith. On the second standpoint is that the plaintiff, under the principle of jus accrescendi, has no interest to inherit from late Mr. Smith. It is on this point that counsel seek the leave of the court to delve into the substance of his argument. Thank you, Your Lordship. On the first standpoint, counsel submit before this court that the plaintiff mother is a joint tenant with no separate share in the property of late Mr. Smith. And Your Lordship, this is the position of the law, as has been judicially noticed in a well-celebrated case of Chenecon and Smith. This is a 1964 case by the Supreme Court, where the court, in its unquantifiable and infinite wisdom,
can you repeat that case? Counsel, can you repeat the
Chenecon and
case?
Smith. Chenecon and Smith.
Okay, sorry.
Yes, Your Lordship. Chenecon and Smith, 1964 case,
Okay,
where the Supreme Court ruled that there are two types of co-ownership when it comes to realties and personalities, and these are joint tenancy and tenancy in common. Your Lordship, the distinction between these two types of co-ownership was also adumbrated by the court, where the court ruled that in a case of tenancy in common, there is always a principle of severance, where each of the tenants or co-owners knows the proportion to which he or she has to the property in question or to the estate. Your Lordship, also in the case of Kuri and Kuri, this is a 1923 case, also decided by the court, where the court ruled that in tenancy, joint tenancy, this does not apply. There is no principle of severance. Rather, the co-owners share the property without any demarcation as to who owns what. My Lordship, it is on this that counsel submits before this court that the tenancy in question or the ownership strategy used for Mrs. Esther, who is the mother of the plaintiff, is joint tenancy. Hence, her share in the property is governed by the principle of joint tenancy as canvassed by the court. Your Lordship, I've gone through the length and breadth of this statement of fact. My Lordship, I've even gone to the extent of turning the statement of fact upside down to see if there's any severance of the estate in question. But unfortunately, there was no severance. Hence, the type of property is joint tenancy. And Your Lordship, counsel submits lastly on this standpoint that the principle of joint tenancy should govern the transaction or the ownership rights of Mrs. Esther, the mother of the plaintiff, when she was alive. My Lordship, going further on the second standpoint, it is counsel's submission that the plaintiff's right, that the plaintiff's mother, that the plaintiff under the principle of jus accrescendi does not have any interest in the property of her mother. Your Lordship, it is the principle of law, it is the principle of law that have been judicially noticed in the case of Chinwezie and Mazi. My Lordship, this is a 1989 case where the Supreme Court gave its judicial blessings to the principle of jus accrescendi and ruled that principle of jus accrescendi follows joint tenancy. Your Lordship, principle of jus accrescendi follows joint tenancy. And this principle connotes that where properties are shared by co-owners under joint tenancy, and one dies, the interest in the property extinguishes, and hence there is no right to the heirs. The heirs of the said deceased does no longer arise. The right of the deceased and its heirs or his or her heirs dies alongside the death of the deceased, leaving the other survivors to share the property until the last survivor, which the shares of the property goes alongside with his or her heirs. Your Lordship, from the fact before this court, it is clear that joint tenancy is the governing tenancy that binds the plaintiff's mother to the estate of Mr. Ololade. And it is very clear, since the plaintiff's mother is dead, her right to the property extinguishes. Hence, the plaintiff, Ibinabo, does not have any right to challenge whatsoever to how the properties are shared, or to even go as far as to ask the defendant, Mr. King, who is my client, to render an account. This is absurd, Your Lordship. This is totally absurd because there is no right existing whatsoever. And Your Lordship, it is on this note that counsel submit finally that the plaintiff's right under the principle of jus acquiescendi does no longer arise. Hence, her right extinguishes with the death of her mother. And we pray this court that this court should rule that the plaintiff does not have any right whatsoever to sue for any account, or to even ask that the property that any share of the property should be given in her favor. And we pray this court to strike out this case for lack of merit, because there's no interest, there's no right, there's nothing whatsoever. And Your Lordship, if counsel is of no further use to this court, counsel seek the leave of the court to resume his seat. Lordship, I can't hear you.
Hello, my lord, we can't hear you. Kindly unmute yourself. Like to speak.
Are you tired of making submissions, or you are done with your submissions?
I'm done with my submission, Your Lordship. I submitted before this court finally that the plaintiff, Ibinabo, does not have any right whatsoever to bring any action before this court, since her right extinguished with the death of her mother, Mrs. Esther. And I pray this court to rule in favor of the defendant and to strike out this case.
Strike out the case on the basis of the first standard.
Bailiff, are you there? Bailiff, if you are there, kindly okay, I think the judges can react. The judges can react, and then we'll give for the remaining time that you have left in your timing, we could give room for rebuttals, if any.
Okay, counsel, can you hear me? Hello, can the counsel hear me?
What did they ask you?
Counsel?
Yeah, I think yes.
Okay, sorry, I didn't mean to take you back, but I just want you to in just a minute, just this principle of jus acquiescendi, can you just briefly just expatiate on it?
Your Lordship, are you referring to the defendant, please? I didn't get.
Yeah, the defendant, yes. He made mention of the principle of jus acquiescendi. Okay,
Yes,
so I just yeah, if you can just explain it in just few words.
Okay, Your Lordship, I will defer proceedings to my co-counsel to explain it, being that he argued the issue before this court.
Yeah,
Thank
please.
you. Thank you. Go ahead.
Your Lordship, can I get the question?
Okay. Yeah. I say just a brief explanation about the principle you made mention of.
Okay. Your Lordship, the principle of jus acquiescendi is not the council's mere intuition, but it is backed up by judicial precedent, which the court, in its unquantifiable wisdom, in the case of Umezulike and Maazi, which is a 1989 Supreme Court decision, where the court ruled that principle of jus acquiescendi by operation of law follows joint tenancy. And the court had the opportunity to elaborate on what the principle of jus acquiescendi is, where the court stated that principle of jus acquiescendi occurs where a deceased, where a person, a co-owner to a property, be it a relative or personalities, dies, that the person's interest in the property extinguishes with the death, such that the heirs or the estate can no longer have any right to inherit from the property. All interest in the property goes to this other surviving.
Answer. Your time is up.
No, don't worry. They are done. No, continue. Don't worry.
Okay. Yeah. Go ahead.
Just round up.
Judges are making comments here.
Okay. The interest in the property goes over to the other survivors, co-survivors, until the last survivor. It is upon the last survivor that the property can go over to the last survivor's estate or heirs, such that the heirs of the last survivor can inherit the property. That's the principle of jus acquiescendi.
It's all right. Thank you.
And this applies in this case.
Okay. Thank you so much.
Yes, Your Lordship.
My learned brother, I don't know if you have any question. Yeah, on mute.
Can you hear me?
Yeah, very well. Thank you.
I'd like to take both sides, Team Diamond and Team Ruby. When you come up to have this kind of exercise, you realize that it's a time to learn. Can you hear me?
No, Your Lordship.
You cannot hear me.
I can hear you,
now.
Your Lordship.
I can hear you, Your Lordship, now.
I hear you. Go ahead.
I can hear you, Your Lordship.
When you come out for this type of exercise, you realize that it's a learning curve. And I realized also that somehow Latin maxims and all of that have somehow been flipped off. So you might not be too familiar with how they are expressed and used. So I'm speaking to both teams because I noticed the referral to Nemudat non habet, and then of course your pronunciation of the word used acquiescendi, and the way you apply the principle. It's you need to look into those things when you want to use them. Luckily, we have YouTube and other apps where you can get the proper pronunciation, and then you guide us properly. And then when you look at the issue of making your issues not too lengthy, because I can drive you round the bend quite take us on a long road when you choose very long issues, and you might lose your points when you are going around trying to explain the issue or even find where the issue started. I noticed that on both sides we have very lengthy issues. In the future, you have to look into that. I think, and of course, some Rodsvival, that's the name of the judge. He was crucified, but we're happy. I think we'll learn from this too. That's Team Diamond. I'm very happy to be here once more. I think everything is clear. I don't know if we have time now for rebuttals, but that's about it. Those are my comments. Thank you.
Thank you so much, my lord. Okay, Belif, kindly call the counsel for the plaintiff for their rebuttals, if any. And then
Okay,
how many
may I
minutes?
call
They have 9 minutes. Yes.
They have 9 minutes. 9 minutes. May I call the counsel for the plaintiff to commence your rebuttal, if any?
Thank you very much, Your Lordship. Your Lordship, we will be covering our rebuttals on each of the issues raised by the defendant. On the first issue, Your Lordship, the defendant argued on the first arm of the fact that the plaintiff does not have local standing, that it is only direct members of a family, of the family that can bring an action in relation to family property. Your Lordship, this position is unfounded in the law, right? As the court in Okul, and they also argued that because she was born to an Ijaw prince, that she is not a family member, has no interest in the family property. Your Lordship, would like to bring the attention of this court to the Supreme Court case of Okoli and Okoli, 2003, where the court held that under customary law, as applicable in Nigeria, where a woman has a child by a man to whom she is not married, custody of the child is deemed to be exclusive to the mother. And this is so even if the child has been acknowledged by the father. This means that where the mother decides to retain the child becomes hers and hers alone. Your Lordship, and then going further, it's not a law that only direct members of the family can sue, because as held by Ukeje and Ukeje, Your Lordship, position, and in Sanusi and Makinde, position under Yoruba customary law is that all children, male or female, are entitled to an interest in family property. And this interest, Your Lordship, continues in the descendants of these children, despite the circumstances of their birth. Your Lordship, this interest continues in the descendants of these children, despite the circumstances of their birth. Accordingly, Your Lordship, in this case, Ibinabo is a descendant of Miss Esther and has an interest, the interest to which was peculiar on Miss Esther, in the family estate, Your Lordship. And this interest is the basis upon which the court, in the case of Sapu and Somunu, held that any family member who has an interest can bring an action. That is the question of local standing. Does she have an interest? And Your Lordship, as a family member, she has an interest on the basis of this case. Your Lordship, on the second issue, the plaintiffs argue that the defendant's argument, rather, Your Lordship, is that a family head is not under any duty to give accounts. Now, what ought to be done when there's misappropriation by family head is to remove the family head. Your Lordship, this is respectfully a wrong interpretation of the decision of the court in that Abara case as cited by the defendant. Your Lordship, the Supreme Court in Achibong and Achibong succinctly held, and I take leave of this court, that it is an inflexible rule and practice that a family head under Yoruba native law and custom must render account of rent and profits realized from the sale of family land. It is only, Your Lordship, it is only upon failure to render this account as ordered by the court that the family head can be removed. So they jumped one position and went to the other. So first, the family head has to be asked to render account by the court. And when he fails to do so, the family can proceed to remove him. This is why the plaintiff has brought this action. Your Lordship, they went further to argue that the plaintiff did not bring the action in a representative capacity. Your Lordship, this is really not the law. And the name of the court, the first position, Supreme Court, in essentially of the Supreme Court, Wifo JSC, in the case of Okolate and Awosaya, when the court held, Your Lordship, when the court held that any family member has the capacity to sue to protect his or her personal interest in the family property with or without the lordship, the consent of other members of the family. This principle was reiterated by the Supreme Court, Your Lordship, in Sapo and Somunu 2010. Citations in our written address. Your Lordship, the defendant's argument that the plaintiff is a meddlesome interloper holds no other, having established that she is a member of the family. So a member of the family with interest in the family property, as put by the court in Sanusi and Makinde and a host of other cases, cannot be a meddlesome interloper. Finally, Your Lordship, on the last issue raised by the defendants, on the issue of use, apprehending, and joint tenancy, Your Lordship, we respectfully do not see why this principle or how they can apply in this case. Because the question is whether the plaintiff has an interest to be protected. And the court, in a host of cases, has held that once a family member, you do not have to prove whether it's a joint tenancy or a tenancy in common. Once you're a family member, you have interest in family property and you have local standing to protect that interest. This interest is not an ownership interest, Your Lordship. That is when these joint tenancies apply. This is an interest of possession, an interest in the proceeds made out of the sale of family property. These were put by the court in the cases of Gegele and Layinko, 1993 Supreme Court, the Lordship, and including the case of Sanusi and Makinde, the Lordship. The Lordship, on the whole, we submit once again that the plaintiff has the local standing as a bona fide member of the family to bring this action. And two, that the defendant can be mandated, and it is within the powers of this court to mandate the defendant to render account. The Lordship. Finally, Your Lordship, before I round up my issues, the plaintiff mentioned trusteeship and the difference in trusteeship in English law and customary law. The Lordship, Supreme Court in Akonde and Akombi held, and this is how we apply the principle of trusteeship in this case, that the duty of the family head to make account is as high as the duty of the trustee to make account. He is, Your Lordship, accountable to family members, especially in relation to rents and profits derived from family property. This was the scope within which we used the principle of trusteeship, referring to the defendant as a trustee of the family property in this case. We pray this honorable court to hold these issues and resolve this case in favor of the plaintiff. May it please this court.
Your Lordship, your mic is muted.
Very well. I think it's the bailiff's turn to guide us on Team Ruby if they have a rebuttal.
Okay. Team Ruby don't have any minutes left for them.
Okay.
For how many minutes did Team Diamond? Team Diamond, how many minutes did they use for their rebuttal? Did they finish up their
They still have 2 minutes more for their rebuttal.
Okay, since they do not have any other thing to say. Yeah. Okay, yes. At the discretion of the court, yes.
I think we can permit Team Ruby to give a 2 minutes rebuttal.
As the court pleases.
With the kind permission of my learned brother, please.
Well, it's only fair.
Eh? Yeah, it's only fair to
have like at this cherry.
As the court pleases.
Thank you.
Okay, Team Ruby, you have 2 minutes for your rebuttal.
Thank you, Your Lordship, for the extra time given to us. We appreciate very much. Your Lordship, we are beginning to wonder what does the plaintiff really want in this case, because looking at the case fact lines 14 and 15, it states that she has sued Akin to account for all payments collected in respect of the family properties. This is the reason Ibinabo is coming to court. But the plaintiff has been raising issues of acknowledgement and legitimacy. We do not see how the plaintiff is being deprived of inheritance to a particular property. What she wants per the case fact is for the defendant to render an account, and that's what she wants. However, the plaintiff has been citing legitimacy and acknowledgement. Your Lordship, it's our submission that legitimacy, we do not see how the issue of legitimacy and acknowledgement applies in this particular instance. Further, Your Lordship, on our next point of short rebuttal, we never argued the issue of representative capacity because the plaintiff mentioned that while he was making his rebuttal. We never made any argument on representative capacity. And on our last point of rebuttal is the plaintiff stated that a family member can sue the family head to account of the money derived from family property. Your Lordship, we are not disputing this. However, the position of the law is very clear. In the locus classical case of Kosoko and Kosoko 1937, and also the case of
Counsel, your time is up. Your time is up.
Thank you very much, sir. Okay, so the judges do have any further statements to make?
No,
if not, we'll close.
But I just appreciate the fact that the council, they made judicial use of their time, and they, unlike the last time, at least they were able to marshal their points within the stipulated time. So kudos to them on that. I think at this point, I think we are okay with the submission, and we are waiting the written addresses.
Foundation.
Yes, definitely the written addresses will be forwarded to your email as soon as we stop this live session. So thank you so much. I would really like to appreciate every one of us. I would like to start by saying thank you so much to Honorable Justice Innocent Umezulike Foundation for bringing this all-important Moot Court competition, a virtual one, to the Nigerian legal education. We really appreciate this giant stride taken by the organization. And we also thank everyone who facilitated. I thank the honorable the honorable judges, Honorable Justice Ife Ejete, and then Honorable Justice Agbade Olumide. Thank you so much for this wonderful outing. I really appreciate every one of you for taking out the time from your busy schedule to join us in this important program for law students in Nigeria. And I also appreciate all the participants, all the counsels from the very first stage to this final stage. We thank these schools for coming on this show. We have the students from University of Uyo. We have students from University of Nigeria, University of Benin, then University of Ilorin. However, we had just 2 finalists for today's finals. And then they are students from University of Nigeria and University of Benin. Thank you so much for coming this important program. We will continue to reach you through mail to know the other modalities. And of course, the final results will be sent to your mail. And then a proper announcement will be made on our social media handles. And so you would know if you emerged the winner of this year's Moot Court competition organized by Honorable Justice Innocent Umezulike Foundation. And so we appreciate all of you for joining in. Thank you so much to our bailiff, Chibuzo Obiora. Thank you so much for the wonderful work that you have done and that you are still doing. And for those of you also who joined in, who are neither judges nor participants, thank you so much. I appreciate the staff and members of Honorable Justice Innocent Umezulike Foundation, both in Nigeria and in diaspora. Thank you so much for joining in. Thank you for the other people who joined in from everywhere. We really appreciate you. And thank you also for understanding and for knowing the importance of this program. This program is one of the pet projects of our foundation. And it speaks volume, especially for the fact that his lordship during his lifetime was known for his extensive, impeccable and astute legal research. And so with this, I say thank you again. I appreciate your time here with us. And so till we'll see again, maybe for another program or for another event, I really appreciate you so much. Thank you very much. I remain your host, Rachel Obudobunseli, Head of Legal and Research, Honorable Justice Innocent Umezulike Foundation. So if you will kindly unmute yourselves, let's hear our voices one more time as we close the session. Thank you and bye-bye.
Thank you, ma'am. Have a lovely day. Thank you, Lordship.
Yeah.
Thank you, everyone. Thank you. Thank you.
Thank you, everyone. I learned a lot for this program.
Thank you. All right. Okay. Bye, everyone. Bye.
Bye.
Thank you.
You'll hear from us through email. Thank you.